I want to welcome everyone to this great March 18 event for the Greater New Jersey Estate Planning Council. We don't have any council announcements today, so I'm just going to kind of go right into our topic and introducing our speakers. In our industry, it's funny, over the course of time, strategies and techniques become very, very popular. And I think over the course of time, sometimes either terminology or strategies themselves become very commoditized. In my industry, you mentioned the terms like split dollar or reverse split dollar, and everybody thinks they know what you're talking about, but there's many, many different deviations and variations of it. And in our industry of the estate planning world, we hear terms like dynasty trusts and DAPTs, DAPs, and there's this generic and benign label attached to strategies, and SLATs are without question one of them. Marty and I were having a conversation recently, and Marty was talking about all of the different deviations and variations of SLATs, but more importantly, how they can be used in many, many different cases and many different scenarios. And the practical application is just very powerful and very flexible. And so we asked Marty to make this presentation today. And right after we did, we got a call from Jonathan Blottmacher, who said, "Thanks for not inviting me." And he wanted to join. And we were very excited to have Jonathan and Marty, both who are good friends, present. But Jonathan was dealing with an emergency situation, and we hope he'll be joining us shortly. But our speaker today, Marty Shenkman, needs no introduction. Marty has been a longtime member of our council. Marty is one of New Jersey's own, and we still take pride in calling him that, even though he doesn't live in New Jersey anymore. But his office is still here, and he practices here. And Marty is a nationally known expert's expert and has lectured on the national scale, from Notre Dame to Heckerling to ACTEC, and you name it, he's been there. He's authored hundreds of articles and written multiple books, and just gives so much back to the industry, and really just brings an expert's perspective and experience to the table. So, ladies and gentlemen, we're very excited about today's topic, and we know it's going to be a great one. So with no further ado, Mr. Marty Shenkman.
Thank you, Eric. When you mention residency, I always think of Richie Greenberg. He always talked about what he called the grandchildren rule. So when somebody says they live in Florida, where are the grandkids, he would ask. And that's exactly, he was right, because we moved to be near the grandkids. Even though it was 20 miles from Fort Lee to where the grandkids were on Long Island, that 20 miles, I probably could walk it quicker, but it would take sometimes 2 hours each way to see a grandkid. So I always think of Richie when I hear that. So the topic is SLATs, and everybody knows about SLATs, and everybody's done SLATs, and everybody likes the SLAT acronym. And we've talked about it so much. What's there to talk about? And let me say at the outset, anything I say is not to disparage any of the other commentators. There's validity and truth and wisdom in all the different comments that have been made by all the different speakers and writers in our profession. But I want to try to give a somewhat different perspective. I think the approach to SLATs, and Eric kind of suggested it, is too narrow in planning. And by the way, with AI proliferating, we have lots of prospects that call us for acronym planning. I had an email from a planner a financial planner in I think it was Georgia. Could I do a backdoor SLAT in Georgia? I had an email from a prospective client. Can you do a beat it in Nevada? People like latch onto these acronyms, clients, even colleagues. And, you got to start with the plan, as you all know. And my perspective, and please forgive the silly analogy, but I think it's helpful. Too often we're focused on an acronym or a form or a technique. Okay, we're going to do non-reciprocal SLATs, and that may be fine. I think if you take a different perspective you can plan better. And the different perspective will help you plan better, regardless of whether you're an insurance consultant, a wealth advisor, an accountant, or the attorney drafts person. And what's the different approach? Forgive me, please. The Lego approach. We all played with Lego as kids, right? You take little building blocks and you cobble them together and you come up with something. If instead of looking at a plan or a document as a SLAT, a backdoor SLAT, a SPAT, a hybrid DAPT, a DAPT, you looked at it as what components can I cobble together to best serve this particular client? That to me is the Lego approach. It and what you'll find, and I don't remember which slides are in here, but I gave you an article, and I know it sounds silly where I estimated that you could do 64,000 different types of SLATs. I was trying to make the point that there's so many different variables that to say something is a SLAT and I like a SLAT or I don't like a SLAT is almost meaningless because there's so many variations of what can be done. Do you have a hybrid DAP provision, a SPAT provision? Do you have powers of appointment? What types of powers? Who holds the powers? Do you have it in a DAP jurisdiction? Do you have loan provisions? Do you have swap powers? Do you have tax reimbursement clauses? You may say, oh, I use all of those. There's still a myriad of variations. What types of distribution provisions do you provide? So to say something is a SLAT is so generic that I think it does us and the clients a disservice. If you use the Lego approach, I think you can tailor the planning better to the actual client. And if you use the Lego approach, I think it's safer for you as a practitioner, whatever field you're in. And I think if you use the Lego approach, you can coordinate better with the attorney on one side, in a sense, and the financial advisor and the insurance consultant on a different side. How so? Okay, we can do a DAPT, a domestic asset protection trust. A DAPT is where I set up a trust and I'm a beneficiary of it. And just for the record, I have a DAPT. I set it up in 1998 within 6 months of Alaska passing the statute. So if you remember the Hair Club for Men, I'm not just the president of the Hair Club. I'm a customer too, if you remember that commercial. But do you want to have a DAPT for the client? It certainly provides more access. So DAPT may make sense. Even though there was a recent Delaware case, the name is something like CES 2007 Trust that upheld a DAPT. There's just a case in Nevada, I can't remember the name, that a DAPT didn't work, but there was an article Steve Oceans wrote in Lissy, Lineberg about it, where he said it was just, I mean, it was ridiculously poorly done. The client who lived in California named themselves the trustee, and they had real estate in California. Of course, it's not going to work. But we could do adapt. I think it's fair to say everyone would agree that if I have a self-settled trust and the client's in New Jersey, it's going to be riskier because there's always that uncertainty as to whether or not full faith and credit clause will undermine it and New Jersey courts will assert New Jersey law. The Nevada bad fact case doesn't really help us because it just means do things prudently, which we all already know. The Delaware case, when the individual set it up, the defendant, he lived in Michigan before Michigan had DAPT legislation. So it was somebody in a non-DAPT jurisdiction setting up a DAPT, but there's clearly more risk. What does this have to do with the Lego approach I'm talking about? What does it have to do with insurance? If I'm doing non-reciprocal SLATs for husband and wife, spouses, I'll just say husband and wife because it's easier. But for two spouses, what access do I give each spouse in each trust? I want to make those different. But if wife dies, husband loses indirect access to the trust he created for her. Well, one option is to have a DAPT or a SPAT where the husband can get named as added, be a beneficiary, or I could do a hybrid DAPT where the husband could be added back as a beneficiary, or I can name somebody in a non-fiduciary capacity, have a power of appointment, the SPAT, special power of appointment trust, and have the husband be able to get a distribution or payment from the trust, not as a beneficiary, but by exercise of a limited power of appointment. Well, all those variations create complexity. And I would say that I would hope we can all agree that adding adapt, hybrid adapt, or SPAT provision not only adds some complexity and also mandates that you want to be in adapt jurisdiction, not New Jersey, but it adds more risk. But that is a way to provide access. On the other hand, I may call up Eric or anybody, I don't know who else is on the call that does insurance planning and say, listen, we're doing non-reciprocal SLATs. I could do adapt, hybrid adapt, or SPAT, but I want you to find out what it would cost and what type of insurance and how much insurance we need to be in the wife's SLAT on her life. I'm sorry, in the wife's SLAT on her life, so that if she dies prematurely, that insurance will make the husband whole. So now I'm giving the client a different option. You can weigh the incremental risk and complexity in using adapt jurisdiction to have a hybrid adapt or a SPAT or adapt, or you may just buy insurance. Which way you want to go? I think it's safe to say, I hope no one disagrees, that having the insurance is less risky than adding adapt or hybrid adapt provision. Well, maybe the client's not insurable. Okay, that changes the calculus. Now we got to go back to the adapt, hybrid adapt or SPAT if the client wants access, if the spouse dies. So the point is that if you take a more granular approach and a broader approach of all the different options that we have at our fingers, at our hands, and you take a holistic approach with financial modeling and forecasting, insurance planning, you can have the insurance and the financial forecasting help inform and decide how much risk the client takes and what provisions to put in. Now, I mentioned SPAT and hybrid adapt and adapt. What does that have to do with a SLAT? How much difference in a SLAT to adapt is there in language? First of all, I'm going to have to be an adapt jurisdiction, but I do that anyhow, and we'll talk about that if we have time. I like to have my SLATs in a self-settled trust jurisdiction, especially if there's two non-reciprocal SLATs, because I think it gives you a safety net that's not talked about enough. But this the SPAT, the adapt or hybrid adapt, it's honestly just a couple of sentences more. It's a minor modification to the SLAT. So when I talk about SLATs, I talk about SLAT-like trusts, because with a SLAT-like trust, I would include in that discussion SLATs, DAPs, hybrid DAPs, SPATs. Which approach I choose may be determined in part on how much what the financial forecast and modeling say, how likely it is the client's going to need access to that trust, whether or not insurance can fill the financial gaps in the plan. So we're already having a much broader approach to the analysis. And I think that's a different perspective on SLATs. So when somebody says at a national conference, I'm not comfortable doing SLATs because of divorce risk, or I'm not comfortable doing SLATs because of the reciprocal trust doctrine, I'm not saying they're wrong. I think there are issues and we have to look at them. But what approach are we using? So take the reciprocal trust doctrine. If you do a hybrid DAP for one spouse and a SPAT for another spouse, those are pretty material differences in the mechanisms of access. Doesn't that differentiate them? And if you're doing them, which I encourage you to do in DAP jurisdictions, you put one in South Dakota and one in Nevada, you have different state laws, different institutional trustees. Haven't you built in a lot of differences to address the reciprocal trust doctrine? And in terms of divorce, instead of doing a pure SLAT, if you do a hybrid DAP for one and a SPAT for the other, just like I said, in the event of divorce, each spouse can be a beneficiary of both trusts. So haven't you mitigated the divorce risks? So I understand, yes, we need to be cognizant of divorce risks when we're planning non-reciprocal SLATs for couples. But if we offer them a hybrid DAP and a SPAT, for example, one in Alaska and one in Delaware, or whichever state DAP states we choose, haven't we kind of given a better mechanism to address that risk? I think we clearly have. So I think the key point of what I want to talk about is take a broad holistic approach. Don't get focused on the acronym, which clients often do. Look at the breadth with the DTH that we can draft, plan, and incorporate into this trust that somehow gets called a SLAT. So the statement on the slide is the devil is not in the details, but in ignoring them. And I think that's the point of what I was just trying to get across. There's lots and lots of variations and options you can do. And Eric told me not to focus too much on drafting, but I think with technology, there's very different approaches to drafting than how many people have handled SLATs in the past. And I do want to talk about it because I think it can dramatically change how we handle SLATs and who we can use them for. So, for example, I've heard people suggest that SLATs for people worth less than 20 million. I've even heard people say SLATs for people less than 50 million are not practical. One of the questions is, well, do they really have enough access? Well, I think they do, with the broader approach that we've talked about. And I think if you have that question answered with financial modeling and insurance planning, you're taking a much more realistic view of how much access they actually need. And that'll vary depending on the client, not just wealth level, but their spending patterns, their lifestyle. And we can address SLATs, I think, cost effectively for clients worth only a few $1 million. But that requires the application of technology. So again, I don't think making broad generic statements about a so-called SLAT is helpful because there's so many different options. And I include in those options DAPs and hybrid DAPs and SPATs because they're really just slight variations of the same trust. And by the way, the traditional life insurance trust, irrevocable life insurance trust ILIT, just a SLAT by another name. Although the traditional ILIT was probably more simplistic and less robust than the SLATs that we typically do today. So some of the challenges and things to consider: divorce and separation. It's interesting. It seems like a couple of years ago, most of the conversations about SLATs focused on the reciprocal trust doctrine. And now they tend to have shifted to divorce and separation. All valid points. I'm not quite sure why the focus of conversations of the planning community has changed. All important points. But again, if you take a broader perspective, hybrid DAP, SPAT, DAPT, I think you with that one change alone, you can probably address in a very significant way the risk of divorce and separation. But I think, again, starting with financial modeling, starting with insurance planning, that can fill a lot of the gaps as well. Death of a spouse beneficiary is an issue. Insurance can often fill that, not always. That's why you may want to discuss with the client taking on more risk with ADAPT, a self-settled trust where the settlor spouse can be a beneficiary if you can't address it with insurance. Creditor protection issues are important. That's an important reason why I also like to be in trust-friendly jurisdictions that have better asset protection. Changes in tax law. I mean, nobody can predict what's going to happen. And that's, to me, not a reason not to do a SLAP, but a reason to do it before the laws do change. But if you have creditor protection, upstream basis planning, and other benefits, it may make a lot of sense. Changes in family circumstances and so on. So let's get into a little more detail. I think everyone knows what a SLAT is, but let me just define it more specifically after a long introduction about them. Each spouse, and I'm going to use husband and wife. It could be spouse one, spouse two, but that gets too confusing when we're talking. But husband sets up a trust for wife that wife is a beneficiary of. Wife sets up a trust for husband that husband's a beneficiary of. And we're going to talk about the Grace case because I think it's often misread and misquoted. And I'm going to give you a novel perspective on Grace that if you go back and read it, I think you'll ponder that I may be right. The key to SLAT-like planning, and again, SLAT-like includes all these different variations, is to discern and determine which variant to apply. So what does the financial forecast say? There's a poll that everyone should pay attention to. I guess I can't click it. So we've had clients where their financial advisors have done some modeling and come back and suggested that the client can only put a fraction of the money in the trust that was intended or desired because their spending level was just so very high. Um, Sometimes you can get around that with different planning approaches. Maybe a residence that is not going to affect cash flow can be in part held by an LLC held by various irrevocable trusts like two non-reciprocal SLATs, so that the couple is not losing access to financial resources. Is there a 2036 issue? Yes. Can you address that? One of the ways to address it is if the home is bought from inception by the trusts, not by the client and transferred to the trusts. I don't know how somebody can argue there's a retained interest, but that's another detailed discussion. But again, having, a residential asset as a significant holding in the non-reciprocal SLATs is another real variation of how the planning might be done. Most are set up as grantor trusts, but you can do a non-grantor variant. I think it was Ed Morrow coined the phrase, and it may have been somebody else, SLATs, Spousal Lifetime Access Non-Grantor Trust. But that's certainly a popular tool, especially post-OBA, because of the benefits from either charitable deductions, QSBS, and other things that could be done. So clearly lots of different things. What are some of the challenges? Oops, sorry, I hit the wrong slide. Sorry. Marital discord and divorce. So let's talk in a little more detail about that. So if there's a divorce, what happens? One of the worst SLAP plans that I've ever seen, I was shocked. The trust provided, and I've heard many people talk about this, but you have to exercise real caution. And this example is why it's never enough for what the lawyer drafts to get the right answer. You have to also coordinate with the financial advisors and the insurance consultants. Everybody's got to be on the same page. What happened in this worst case scenario of non-reciprocal SLATs? The couple was very worried about asset protection issues because of their professions. And what they did is they put 80% of their wealth into these non-reciprocal SLATs. I think the amount was excessive and probably would support a fraudulent conveyance claim simply because it was just such a huge proportion of their wealth. I remember years ago, and I don't know if the rule still applies, but in talking to Gideon Rothschild on how much wealth he felt comfortable having somebody put into a foreign asset protection trust, I may be wrong, but I believe he said something like 30% or a third of their wealth. 80% is just way over the top. But here's what made this a disaster of a plan. And this is a commonly talked about tool because of the grantor trust issues. What's the grantor trust issue? If there's a divorce, the settlor spouse, let's say the husband created a SLAT for the wife, remains taxable on the income of the SLAT even after divorce. That is a concern that certainly would upset many, if not most clients, that they would bear the income tax cost on their ex-spouse getting the income from that trust. So the approach that is suggested, and I'm not saying the approach is wrong. Again, it depends on the circumstances. The approach suggested is if there's a divorce, remove the spouse as a beneficiary so the settlor spouse doesn't have to bear the income tax cost on the SLAT after divorce. Now think of this extreme example, which is a real case that I had where 80% of the wealth of the couple was put in the trust. Both trusts provided that in the event of divorce, the spousal beneficiary is removed as a beneficiary. In effect, in the event of divorce, both SLATs transform into dynasty trusts for the kids. If this couple gets divorced, they won't have money to live on. Their kids will be prematurely very wealthy, and they will not have financial resources. Period. What a disaster. So, does it make sense as an option to plan for divorce by saying the spouse won't be a beneficiary in the event of divorce? The answer is maybe. And whether or not you do something like that depends on what portion of the wealth are they putting in. If this couple was worth $40 million and instead of putting in 30 million or something into these trusts, they put in 5 million into each trust, maybe that's fine. But if you put in a large chunk of wealth, maybe it's not fine. If you have a client that's worth $10 million and they put 2 million into each SLAT, you don't want to have each spouse removed as a beneficiary because that's 40% of their wealth. And at that wealth level, they may very well need the money. If this couple's worth $200 million and they put, 30 million, 15 into each SLAT, maybe it's not an issue. So it all depends. And you really need to look at the numbers in conjunction with the wealth advisor, the attorney, and the insurance consultant to see what makes sense. So one approach to deal with marital discord is to remove the spouse, but that has to be a case-by-case analysis as to whether it makes sense. Another approach is to use a floating spouse clause. So in the SLAT that the husband creates for wife, it doesn't say that Cindy Smith is the beneficiary no matter what. It may say whoever John Smith is married to will be the beneficiary, maybe vice versa in Cindy's trust. Alan Gassman has an approach that he recommends that's interesting and that he uses. And again, it all depends on the circumstances. He'll have the SLAT divide in two, and half of the SLAT, half of the post-division SLAT will remain for Cindy Smith in our using the same hypothetical, and the other half will be a floating spouse clause in the event of divorce. So that way, there's no grantor trust burn on half of the assets. There is on the other half, but you're preserving access to the money. So those are things that can be done. You can have floating spouse, a division, and have partial floating spouse. You can have spouse removed, lots of different options. And don't forget, if the couple has significant other wealth in the marital settlement agreement, they can negotiate what happens in terms of the overall economics reflecting the tax burden that the settler spouse may have to carry. So just on that one point, there's lots and lots of different approaches. Let me, and forgive me, I don't remember if these slides are in the deck, so I'm going to talk at this juncture since we started talking about divorce. Let me talk about the realistic assessment of divorce. Is divorce a significant potential risk for clients? Absolutely. I've just given you a whole bunch of different ways to deal with it. Which way or which combination of ways will depend on all the factors unique to the client. The other consideration, which I think is very important, and this is not the only time or circumstance where I've seen this misconception. We joke about like the average American family has 2.3 kids. Boy, what does that 0.3 of a kid look like? You have to be very careful applying statistics. There was a book written more than a decade ago, I think, by Charles Murray called Coming Apart. And it was really a social commentary on America. And he did a very fascinating analysis of the social structure in America, wealth, education, and so on. And he had this concept called super zip codes. And those were a very limited number of zip codes where the people were very wealthy, very highly educated, and his children went to elite schools and then tended to marry people who were also very educated and very wealthy to perpetuate this sort of social structure. And one of the things that he talked about in that construct was that the divorce rate for that social elite, highly educated and wealthy, was, I think the percentage he had was like 25%. It was half of the 50% stated rate for the population as a whole. And by the way, half the divorce rate of the population as a whole is a reason that wealthier clients tend to accumulate and maintain wealth because the divorce rate is low. If you actually look in some detail at divorce statistics, a large percentage of the divorce statistics are heavily weighted in terms of new marriages, young people, people at lower economic levels. One of the primary reasons for divorce is financial strain, which is much more pronounced at lower economic and wealth and income levels than the clients that most of us typically see. So, what does that mean? And I did not fact check it. I don't have the statistical background, but I tinkered using AI, and Eric will attest to the fact that AI is always right. And you don't want to fact check anything in AI. So forgive me, but I just want to make the point. And even if it's off by a significant percentage, it still makes the point. I asked AI, knowing now that there's a correlation between lower divorce and higher wealth, there's a correlation between higher education and lower divorce. And by the way, some of the reasons for that is more educated people, college and above, tend to get married at a later age and maybe make better decisions because they're more mature, they're getting married older. And there's also a correlation with the longer the marriage, the less likely the risk is for divorce. In other words, most divorces occur early on in a marriage's history. Gray divorce is a bit of an exception, so we need to be mindful of it. If you factor in wealth, education, and duration of marriage, the divorce rate is substantially below that for the population as a whole. The numbers that AI gave me when I had to do some research, and I did not check it. I don't have the statistical knowledge to do it, and I think the number is low, but it really makes the point. Is for somebody with 5 million net worth, which is probably less than the typical client most of you will ever see, less 5 million in net worth, 20-year marriage, and college education. Many of our clients are worth more, longer term marriages, and greater education levels. It came up with a divorce rate of something like 10, 11%. Now, even if that's low by 50%, it shows how dramatically lower the divorce rate for the client base that estate planning professionals and all the allied professions see and advise than the population as a whole. Does that mean we ignore divorce? Absolutely not. But if the divorce rate for our client base is 10 to 15% instead of 50% or close to 50%, you have to be very mindful of the decision process you go through. I've just talked about a whole bunch of different ways we can address divorce and SLAT planning. But if the divorce rate were 50%, I agree with some of the comments I've heard made. Boy, I don't know if I'd ever want to do a SLAT. I don't really agree because what's in the SLAT? That's the key point to the whole lecture. You know, do you split it like Gassman does and have half floating spouse, half not? Do you make hybrid DAP and SPAT, in which case I'm not sure how negatively impactful the divorce is going to be because we can work it out. We have access to both trusts for both spouses. But if the divorce rate is 10 to 15%, we can't say to clients, no, I'm not doing that kind of planning because it's too risky given the divorce rate. It's a mistake. And by the way, if the divorce rate's 10 to 15%, what's the likelihood of the client getting sued? So if you have surgeons, and I may be wrong on the statistic, but what I remember, it's something like once in 5 years, every surgeon gets sued. That's like a 20% rate. That's a much higher rate of lawsuits for surgeons as clients than the divorce rate they may face. So you're going to tell me you're not going to do non-reciprocal SLATs because you're concerned about divorce when the lawsuit rate is higher, and that's not even counting the other claims they may be subject to. So I think we really need to be much more granular in our analysis. We have to be very mindful of not applying generalities that may or may not apply to our clients. And I also think the approach is the wrong approach. It's not for any of us to tell our clients the divorce risk is too high. We need to explain, listen, if there's a divorce, you, wife, are going to still pay income tax on that SLAT's income, even if it's going to your husband, because you're not a beneficiary. Hey, we could put it in Nevada or South Dakota or Michigan or New Hampshire and make it a SPAT or a hybrid DAPT or ADAPT even. That's going to cost you more money and have greater risk of creditors piercing it or estate inclusion. But that's a choice for the client to make. Hey, client, you need to weigh, just as the example I just gave, how much concern do you have about asset protection versus how much concern do you have about divorce? I had a famous client, obviously can't tell you his name, many years ago, and he was getting married for the fifth time. And I said, Joe, not his name, Joe, why don't you get a prenup? And he said, I don't need one. I said, Joe, you told me that the last four times. So he said, no, this time is different. I said, Joe, you told me that the last three times. He says, no, this time it's really different. I said, why? He said, after this one, it's either the cemetery or the monastery. So he wasn't worried about divorce. Joking aside, it's the client's decision how to weigh the risk of divorce versus the risk of lawsuits versus their desire for estate inclusion in case the rules change or if they're taxable now versus being able to get some upstream planning by giving a GPOA to an elderly family member on each of the slats. The clients have to weigh the risk, not us. So I think the perspective has to be done that way. In looking at slats, I don't know why every time I move the cursor, sorry, it moves the slide. Just some of the other points. Does estate tax exclusion really matter to the client? Or do you want estate inclusion in order to get a basis step up? Do swap and substitution powers suffice for that? Can you do asset location decisions so that you have your bond portion of the portfolio or actively traded securities, which may not have the same appreciation over the long term as a buy and hold strategy? Can the financial advisor control the appreciation in the SLAT? So the decision about estate inclusion, good or bad, isn't only a legal or tax planning decision for the attorney. It depends on what the wealth advisor can do in terms of asset location, not allocation. Family circumstances may change. What can you do? Well, powers of appointment, uh, flexible trust protectors, and so on. Trust income taxation. Taxation. Do you want grantor or non-grantor trust? If you're trying to save state income tax with a SLAT-like trust, in New York and California, and I would imagine other states would follow at some point, you can't have an incomplete non-grantor trust. They're going to tax it. But if you have a completed gift non-grantor trust, you can avoid state tax. So when you start to look at all the permutations of what we can do with just this one slide in terms of divorce, remarriage, creditor protection considerations, state of situs, dealing with tax law changes, flexibility to add different beneficiaries, income tax structure, complete a gift, not complete a gift, to talk generically about a SLAT that can encompass so many different things, I think is not necessarily helpful. We've already covered that. We've talked about floating spouses. You can use powers of appointment, right? Collateral lifetime powers of appointment in favor of a class that may include the settler spouse. Some call that a backdoor SLAT. You can use it as a SPAT, same concept. Power to add or remove beneficiaries in the hands, and I don't like to do that with a trust protector. I'd rather have somebody that's clearly in a non-fiduciary capacity. If there's any potential that the trust protector is affirmatively named to be a acting in a fiduciary capacity or under state law might be construed as such. The broader the class of beneficiaries, the more the planning opportunities. And just the flavors was Teresa Bush from Interactive Legal's idea. And the title at one point was 31 Flavors of SLATs. Again, the idea, and forgive the silliness, but the idea was to try to drive home the point that talking about a SLAT can be unhelpful because there's so many different variations of it. And she started labeling them with flavor 1, 2, 3, 4, 5 to 31, and at some point gave up. But the point is there are so many variations of what this is. Okay. I'm going to skip the drafting. Let me just comment for a second about this, but not in terms of what the drafting software specifically does. Let me try to give a more planning focused discussion that makes sense to understand both as an attorney as well as the allied professions, trust officer, financial advisor, and an accountant and insurance consultant. So we talked about a number of different options. This is the options they give you in interactive legal, and I talked about other options as well, like the Alan Gassman's approach of dividing the trust, making half floating spouse, half the spouse, using SPAT and DAP and hybrid DAP provisions. So there's at least a half a dozen different approaches that I just rattled off for dealing with the issue of divorce. And keep in mind that the divorce rate for our clients is much, much less than the, not to be ignored, but it's much lower than the average statistic, which is very misleading for our client base. Here's a couple of general concepts. First, and I'm repeating something I said earlier, but I think it's so important and it doesn't happen enough. Helping evaluate which approach to use is you'll get a better result that's more tailored to that client by involving the wealth advisor doing financial forecasts, the insurance consultant dealing with insurance planning. Because keep in mind, it's not just divorce, it's also premature death of a spouse. If there's no way for the settler spouse to access it, the insurance could save the day. And dealing with premature death is as important as dealing with divorce. Again, here's the concept. Do you draft your non-reciprocal SLATs using a template that you have in your office? I suspect many people still work that way. But if you're working that way, do you have all the myriad of variations, not just on divorce that you see here? And I gave you 3 more than what's here. So 6 variations on how to handle divorce in a SLAT, at least 6. And there's others. A loan power, in effect, is a way to also do it because the settler spouse could get a loan, right? Investment trustee or investment advisor can change the investment allocation and reduce the grant or trust tax burn to the settler spouse post-divorce. There's a myriad of ways to deal with just this one issue. If you're drafting from using a firm form, can you possibly address the 8 or 10 different variations on just divorce that I just said? I think the answer is no. Because if you only have a template, can you do that? We're going to take a 2-minute break. And when we come back, what we're going to do is continue with that. And I want to explain how I see people using AI to draft documents. I just saw a demo using Harvey, and I want to explain why that has the same shortcoming of what I did. We're going to take a 2-minute break, and we'll begin momentarily. Okay, we're going to restart. Sorry about that.
If there's, Marty, before you start, I just want to say to everyone, if there's any questions, feel free to, put them in the chat. And Marty always likes presentations to be interactive.
Yeah, please do. I thank you, Eric. I completely forgot to say anything. Eric is going to monitor the chat because I can't go through the slides and monitor the chat. And if there's questions, he'll interrupt me, and I'm fine doing that because there's no reason not to try to make everything I say as relevant as I can, as helpful as I can. So some firms, and I don't know that there's any data on it, use drafting software, and it doesn't matter which one. Some firms use a firm form for an ILET or a SLAT. There's an attendance poll you got to click. And if you're using a firm form, you have to evaluate, can we get the variations that I'm talking about? Because the variations is how you tailor it to the client. The variations, I think, is how you can offer client options. And I'm going to explain to you, I think, a different approach to doing that I think is very protective of the drafting attorney and everyone else on the planning team, that I'm not sure too many people use. I haven't seen it used elsewhere. But I want to talk now about using AI. So there's Harvey is a AI platform that's really being developed and being enhanced for law firms. I saw a demo about how Harvey could draft certain documents, and it was fascinating. And I think it's actually detrimental the way it was being applied. What was the application? I think it was a partnership agreement, a merger agreement. There was some entity documentation, and the attorney said, get the standard firm operating agreement. That wasn't what it was, but it doesn't matter. Get the standard firm operating agreement. Here are the 5 changes I want you to make to it. And Harvey drafted the documentation and somehow highlighted all the changes made. The associate then reviewed the entire document, noting the changes that were made so that you still have lawyer input, lawyer review. And now they have a document, much more efficient, faster than what we could do without AI. What's the shortcoming of that? It's no different than the old style of practice where you have a firm ILET form and you have a junior associate take the insurance trust form and draft that trust, tailor that trust for the Smith family. The AI is faster and more accurate, and the associate is actually functioning, I think, at a higher level using AI, but it's the same shortcoming. The firm form, the same mindset of using a standard firm form, can you possibly integrate the 8 different approaches to addressing divorce that I rattled off? I don't think so. I don't think so. Whereas using drafting software, and there's a number of different options, I'm not promoting one or the other. If you're using drafting software, you can check the box. There's lots of options. And I've given you more options than this particular software even offered, but it still gives you a whole bunch of different options. So to me, I hate to say the better way to practice. I think it is, but I don't want to in any way imply anything negative about what people are doing. But think about the inherent limitations of using AI the way I saw it demonstrated and using a standard firm form. And maybe that's why so many people have the perspective of talking about a SLAT. When you use all these different options that are available, you can better tailor it. And again, sorry to repeat, but if the client is not insurable, then I may add a SPAT or hybrid DAPT or DAP provision, all coordinated. Now, let me tell you an interesting way, and I'd love to hear if anyone is doing this. Here's how I draft a document. I use document generation software because I want to have all these options. There's many different ways you can use document generation software. For example, many people create a preset template so that if you want an ILET, the associate can, or even an admin person, so it's even more profitable or lower cost, admin person can fill in the names and things into the template, and use the insurance trust template that you've pre-selected. The shortcoming of that, the negative, is you don't look at all the options. The positive is it's more cost effective or more profitable, depending, whether you lower the cost or whatever. Here's what I like to do. I go through and draft the document using document generation software. I do it on a Zoom meeting and record the meeting. So when I look at a provision like this, I say, okay, we've discussed in our meeting the potential risk of divorce, and you were not concerned, if that's in fact the case, with a risk of divorce in your planning. You were far more concerned with asset protection and other benefits that the SLAT, non-reciprocal SLAT plan offered. Just so you're aware, we discussed that you could use a floating spouse clause. Then I may define it. You could divide the trust, which we discussed, and have half floating spouse and half remain each spouse. You could use a SPAT hybrid DAPT or DAPT approach to get more access post-divorce. You opted not to have the extra complexity and cost and preferred to keep a local trust with family members in New Jersey to minimize the cost. And also you were concerned about the extra risk that can't be quantified for a SPAT hybrid DAPT or DAPT. That now, when I'm done drafting, and we've gone through all the different templates and all these different decisions, I get a transcript from the Zoom call, and it's secure. You just make sure your settings are right. And then I upload it into AI and say, draft a memo, but I have a much longer prompt. It's like 20 lines long, because each time we use it, we develop and refine the prompts we use, telling AI how to draft a memo from that transcript. I can have, with 15, 20 minutes of work, which an admin could then do, a 6-8 page memo going through all the different options that we talked about, and a lot of options that we didn't discuss in the meeting, offering those options to the client and telling them what we did and what we didn't do. It's not only helpful to explain all of what was done to the client, I think it's incredibly protective for everyone on the planning team, because you now have summarized lots of options for the client to be aware of, so the client, not us, is making the decision. I think it's incredibly protective. And think about it. You're drafting anyhow, so maybe it takes you an hour to draft a sophisticated SLAT, and in 15 or 20 minutes of even admin time, you have a detailed memo going through 50, 100 different options that could have been in that trust. It's a very different approach to practice that I think is more understandable to the client, gives the client the control. And by the way, and I'm not addressing attorney-client privilege, which might be tainted by this, but if you give that memo to the other advisors on the team, now the financial advisor, the accountant, the insurance consultant, anyone on the team now knows exactly what was done. And if they have a different perspective, like the accountant may feel, it's the wrong approach from an income tax perspective, or the accountant may feel that from a gift tax perspective, maybe there's something they caught that we as the drafts person didn't. They're seeing all the thought that went into the process. So I think there's fascinating and different ways that we can approach this concept of what some call is merely a SLAT. So this is just as another illustration. You can give a special power of appointment to a person, and there's lots of different variations. You can say it can't be exercised for a year, for 10 years. You can modify it. You can require the approval of an adverse party. We just had that in a situation because somebody was trying to draft. I forgot what the goal was. But again, you can discuss all of this while you're drafting, and thereby, with modest additional time, communicate it all to the client. Yes, when you get the draft memo from AI, and the better your prompts or inputs directing AI on how to do the memo, the better the output. And I'll give another comment in a second, but maybe it takes an hour or two to modify this long detailed memo, but think of the value add to the client. Think of the coordination of the planning team. I think it's a very different perspective, trying to harness document generation technology, AI, and all the tools that we really are now having available to us. One of the issues, and this was mentioned at Heckling, and I just, it was like a V8 moment. What a brilliant idea. I think it was Bruce Stone, but I may be wrong, said to address in your retainer agreement that, specifically whether or not you need to disclose confidences from one spouse to the other, but also made the comment that if one spouse attends a meeting and the other doesn't, both spouses agree to that, and the spouse that attends the meeting agrees to inform the other spouse of all the discussions at the meeting. I thought it was a very clever concept. We all get clients where one or the other spouse is too busy or something comes up or whatever and doesn't show up at a meeting. Very protective. I thought that was interesting. And we need to think about in the context of the risk of divorce is not just how we draft the SLAT, but what we put in our engagement letters. And I think that's something that is not just for the attorneys, but for every practitioner in all the fields, because what happens when you have this sort of disparate view between the clients. Now, here's something else that we've been doing for years, and I wish I'd thought of it even years before. When you give a client a draft of a non-reciprocal SLAT, they should be responsible to review it and understand it. But I was concerned that some clients are not understanding it. And I'm not saying this is a standard of practice because it's being recorded, and I certainly don't want to put this on anybody. But what we started doing, and you may think about it, is we have a pretty lengthy cover letter that goes out with our draft irrevocable trusts. And there's a section for non-reciprocal SLATs where we list the differences built into each trust. Why do I do that? Because there are different distribution standards for each spouse. There are powers of appointment. Just think about the 5 and 5 power, right? Everyone knows you can give somebody the power to withdraw the greater of $5,000 or 5%. You put 10 million in a SLAT, and the spouse can withdraw 5% of that every year, which is $500,000 if my math is right. That's a lot of money. Think about, and I did a projection, an article with, I'm blanking on the name, from Bison Trust, where they showed, okay, while the let's say husband was alive, the wife didn't draw out using her 5 and 5 power. The minute he passed or was incapacitated, for like the next 10 years, she drew out 5% of the trust, invested it, and then bequeathed all of that to her kids from her prior marriage. It was really eye-opening, eye-popping, how much wealth she shifted from the couples plan, which was going to go, let's say, half to each batch of prior kids, to just for her kids using just the 5 and 5 power. I think it's worth considering highlighting in a letter communication to the clients that they understand that the differences you build in to make the trust non-reciprocal have real economic impact. I worry that some clients may think, oh, yeah, you're doing that for tax reasons. Great. No. We are doing this for tax reasons, but they have real and very substantial economic consequences. That's another fascinating role for the wealth advisor to play in SLAT planning. One is the forecasting to see how and when they need to access assets, which, by the way, I think is very good to deflect a fraudulent conveyance claim. If you can show that for years, for 5 years, 10 years, they don't need to access anything, even longer is better. You can also show what some of the different distribution provisions might mean, like the exercise of a 5 and 5 power. I also think it really is protective of the attorney to have the wealth advisor, the insurance consultant, the accountant to either be in on a meeting or meet with the client to separately or on their even on the same meeting discuss the SLAT plan with the clients, because now you have another professional meeting and confirming in their notes, however they keep their records, what they discussed with the client. So if the client ever comes back and says, oh, you never told me if there's a divorce, I'm going to be paying the income tax. No, the accountant met with you and they told you the same thing. We both have similar notes, meeting you like, a month apart, talking about the same issue. Very helpful. I also think for clients, it's helpful because this stuff is very complex to most clients, and hearing it from different voices with different lenses from each advisor is very helpful for them. I said it earlier, but I'm going to repeat it here. Offering the DAPT, hybrid DAPT, and SPAT, I think, is protective, and it lets the clients make decisions on how they want to deal with this issue. Don't forget premature death. Insurance is a great way to address that, not done enough. In many cases where we're doing non-reciprocal SLATs, one spouse may have maybe putting the assets in and funding a trust with their exemption. And this is much more common in 2020 and 2021 because there wasn't enough wealth to fund both SLATs. And that creates a bigger risk for divorce or premature death because there's a SLAT that one created, but not the non-reciprocal corollary. We may set up a separate SLAT-like trust for the spouse who's not funding with large assets and use it to hold insurance. Because again, the SLAT is just a more robust version of the traditional life insurance trust. And even if we put the SLAT with the big asset value in a trust-friendly jurisdiction like New Hampshire or Tennessee, et cetera, the SLAT that's going to function like an insurance trust primarily and not get a large dollop of assets on the funding, maybe we just keep in New Jersey to keep a family member trustee and keep the costs lower. Lots of ways to plan for death. SPAT, hybrid DAPT, and DAPT are great ways to give the settler spouse access. I think you should offer them. Client may say, you know, now that you've described the risk and the cost and that I have to be in a different state, I'm not comfortable. Great. Now that's the client's decision. They made an informed decision. It's like the Cy Sims view, you know, our best customer is an informed consumer. That's what we want. You can have powers to add or remove beneficiaries. That's or like the SPAT, so that the settler spouse can be added. Creditor issues. So, and this is why I get concerned when people cite average divorce statistics and get concerned about whether the client has enough wealth to do non-reciprocal SLATs or that they don't want to do SLATs because of the divorce risk. There's a strong correlation, and forgive me, I don't remember any of the data other than the one I quoted earlier on surgeons, which is very high, but there's a strong correlation with wealth and lawsuits and claims. And it makes sense. It's like the Willie Sutton approach. Everybody remembers Willie Sutton, the famous bank robber who once was asked by a reporter, "Hey, Willie, why do you rob banks?" And Willie kind of looked at the guy and said, "That's where the money is." I mean, our clients tend to be very wealthy and they do face risks. So if I can start a non-reciprocal SLAT plan, especially years before any claim, you know, while the client's even young, even when they don't have a great deal of wealth, and maybe they only put in $500,000 in each SLAT, but now we've started them on the asset protection path long before any claim arises. The recent case, which was very favorable to uphold DAPS in Delaware, and it's like an odd name again, CES 2007 Trust or something like that. The court waxed on about how this self-settled trust was created 7 years before the business endeavor that led to the claim arose. Think about that. Too often clients wait until they have a problem, right? We all get the phone calls. Do you do asset protection? And I know as soon as they tell me, do you do asset protection? You know, it's like, you know, what happened, right? They're not calling about asset protection because it's a theoretical future issue. They often call because it's already a bad done deal. And by the way, that's another interesting application of AI. So I had somebody call me recently and said, "Do I do asset protection?" And I said, "I can." What happened? What's going on? And the prospective client assured me nothing happened. It's all theoretical. Something happened years ago. Nothing became of it, and he just, you know, felt that, you know, it was time to try to be a little more cautious. I used, and I'll just mention the software because it's what I did it with, Estate View. And Estate View can do background checks. The advantage of using something like Estate View is they've programmed in all the details of the prompts of how to do it, where to look, And I don't know how to replicate what it does. So while I'm talking to this prospective client, I put in their name and some of the background information they gave and had an AI background check done. And before I got off the phone, apparently there's lawsuits already filed against this prospective client on the matter they're telling me was hypothetical. So first of all, I'm not taking them as a client because they lied to me. But secondly, I'm not getting involved, and some of you may have different views of this, but I'm not comfortable getting involved in somebody trying to transfer assets when there's already docketed cases against them. So creditor issues are important. And this is also why I don't agree with the concept that unless you're worth X dollars, don't do SLATs. If husband and wife, and again, it could be spouse one, spouse two, whatever you want, but I'm going to call it husband and wife, set up non-reciprocal SLATs in trust-friendly jurisdictions, Alaska, Nevada, for example, and they each put in $1 million or $500,000, whatever they can afford now. So it's not a fraudulent conveyance, it's not unreasonable. And they get it started. And then each year they put in more money. Think about how safe that is. According to the recent Delaware case, CS 2007 Trust, they have trusts set up so the trusts are getting old and cold. They're making gifts long before they may even have a claim. Think about also from a fraudulent conveyance perspective. If next year they put in 100 grand, 200 grand, and the year after they put in nothing, but the year after that they put in another 500,000. As they put it in, each transfer is kind of weighed against their wealth at that point and the claims at that point. And I think that's much more secure than putting in 50% of your wealth day one and oh my, there was a claim they didn't know about. Starting a pattern can make a lot of sense. And by the way, for younger clients that want to get started on the asset protection path, if they're each putting money into or assets, and obviously you want to, if you can, have different assets, different amounts to help again make the trust look different. Starting now, I think it could be very valuable and safer and gets them on sort of a program of ongoing asset protection. If they have an elderly family member and you give a general power of appointment to that elderly family member, they can get a basis step up on the passing of that elderly family member. And I'm not going to get into the details and the risks of using upstream planning. I think a lot of the risks are not really addressed or talked about, but it's certainly common planning. Think about that as a wealth advisor. If your client sets up, your young couple client sets up non-reciprocal SLATs, and 5 years from now, Aunt Jane, the elderly Aunt Jane dies, and she had a GPOA, and they eliminate all the built-in capital gains from when they first met you until 5 years from today, you've just hit a grand slam for them. They're going to be very, very happy. So it's not just creditor protection. It's not just a state tax exemption. There's an attendance poll you need to click, everybody. So you really want to balance all the different benefits and goals from this. And by the way, doing that also helps support the asset protection planning, because if you have income tax goals like upstream basis planning, if you have possible estate tax goals because the client or even you just document after explaining to them is concerned that the exemption may decline in future years, you've really documented that. Let me go back because I just, and forgive me, I meant to say something earlier. I've talked in a number of these contexts of using trust-friendly jurisdictions, Nevada, Alaska, South Dakota, Delaware, New Hampshire, Tennessee, et cetera. And there's over 20 of them now. So it's not an anomaly. Alaska was the first in 1997 or 8, but it's now over 20 states have permit self-settled trusts. And yes, I recognize and acknowledge New Jersey doesn't, so you always have a full faith and credit issue. It's not been resolved. You may view in different ways the weight of that recent Delaware case, but it certainly seems to be a worthwhile strategy, but caution the clients. Why do I like to have SLATs, non-reciprocal SLATs in different DAPT jurisdictions? And I don't hear this talked about much. If the IRS or a creditor, it's not just a tax issue, it's a creditor issue as well. If a creditor or the IRS can uncross the non-reciprocal SLATs, it's treated as if Husband set up his trust, wife set up her trust, not that husband set up a trust for wife and wife set up a trust for husband. Why do I want those in adapt jurisdiction? If husband is deemed to be the transferor to the trust that wife set up to benefit him, if you uncross them and you're in adapt jurisdiction, not in New Jersey, that trust may still be valid. In Alaska, for example, you have to have a solvency affidavit signed, but I would do that anyhow. But don't you have a fallback argument to say, hey, okay, you uncross these non-reciprocal SLATs, they're still out of the estate, they're still not reachable by a creditor because that jurisdiction permits a self-settled trust, and this is a self-settled trust. So that's an interesting point. And forgive me, but it just dawned on me. There was another point I made that I didn't connect the dots on. I said something that I was going to tell you an interesting concept in the Grace case. There's been a lot of talk and focus lately, and I'm not disagreeing and I'm not disrespecting anyone who said it, with divorce and SLATs. And I don't disagree with any of it, but I've tried to give you a more nuanced, granular perspective and really assess some of the statistics better. Go back and take a look at the Grace case. It's not that long, but the Grace case has a very common theme with the Smaldino case, which I think was in 2020 and was a step transaction case. The Grace case was long ago about the reciprocal trust doctrine. It was sort of the seminal reciprocal trust doctrine case. And there was a recent case that Carla McCaffrey talked about in the recent development section, if I'm correct, at Heckerling. It's like just a bunch of initials like CR versus HS, or I don't remember the initials. It may be in the materials. And it was a divorce case where the plan was unraveled because the husband so manipulated and controlled what happened. Basically put documents in front of the wife and said, sign here. Go back to the Smaldino case. We all read that from this step transaction perspective, and it was a really bad fact case. Lots of good lessons to learn about how to do better planning and implementation. But in Smaldino, the husband totally controlled the process, just like in the New York matrimonial case that I just mentioned, and basically used wife as a conduit to put assets in a trust for his kids. And she just went along with whatever he asked her to sign. Read also the Grace case. In Grace, the husband controlled the entire process. I think it was employees of the husband drafted the trust. The husband told the wife where to sign, and she acknowledged in the case that she just signed whatever he told her. You know, when you have one of the two spouses, and it could be either spouse, so overly controlling the process, that I think could be a greater risk to the practitioners and to the plan than this issues of divorce and reciprocal trust doctrine. Be aware of that. Take a look at Grace, Smaldino, and that recent New York matrimonial case, because that's something we all see in practice. One of the spouses overly controls, dictates what's going on. That's where we as practitioners and in all the professions need to be careful. So in terms of asset protection, going back to this now, I would try to set up any kind of non-reciprocal SLAT or SLAT-like trust in an asset protection jurisdiction. If you're doing hybrid DAPs, DAPs, or SPATs, you really should do that. You could theoretically say, okay, I'm not a beneficiary today. The trust protector has the power to remove and replace the trustee, change governing law in situs, and until such time as the trustee moves the trust and changes the sole trustee to adapt jurisdiction, Uncle Joe, who has a limited power of appointment, a SPAT provision, can exercise it in my favor. You could theoretically do that. I'm not sure if a court in New Jersey would be able to pierce that. I'm not aware of any law, but I think you're better off starting in the DAP jurisdiction than risking that. I don't, if anyone has more precise knowledge of that, I'd love to hear it. And by the way, something else in SLATs, how much indirect access can you have? Too many times, whether it's the client or the advisor, oh yeah. If husband sets up a trust for wife, husband can indirectly benefit. You got to indirectly benefit with consideration and caution. So, for example, if wife gets a $100,000 distribution from the trust, and husband goes and it gets deposited, where? Does it get deposited in the joint checking account? Let's say it does, and husband goes out and buys a car with that 100 grand. That's kind of a little bit more than an indirect benefit. I think an indirect benefit is the SLAT owns a vacation home, and because the husband's married to the wife and the wife is a beneficiary, husband can tag along with her when she goes to the vacation home. You got to be careful with that. And I think that's sort of a lesson of the Sorensen case, the Smaldino case, all these cases where how people administer the plan is really important. And too many clients don't come back to let the team administer the plan. Big mistake. These plans are not simple, they're not without risk. And one of the better things to do for clients to assure success of the plan, whether it's asset protection, upstream planning benefits, income tax benefits, is to let their advisory team periodically review all that's going on. So this is just, and I can do it very quickly. This is just an overview, sort of summarizing all the different variations of SLATs and SLAT-like trusts. It could be a grantor trust for tax burn. It could be a non-grantor trust because of QSBS benefits, SALT benefits, charitable contribution benefits. You're trying to get income outside of New York or California or any other high tax state. It could be a completed gift or incomplete gift for estate tax purposes. Big difference. GST exempt or not exempt, right? So if you just add all these variations, there's just so many different things to do. Do you have a general power of appointment for upstream planning? Do you have a GPOA? Which formats for access do you provide to the settlor spouse, even to the beneficiary spouse? So, are you using insurance or not using insurance? I don't think I've ever seen it really addressed, but let's say we set up non-reciprocal SLATs and husband puts $10 million into his SLAT for benefit of wife. Wife puts in $2 million to benefit husband, but also buys a $10 million permanent insurance policy in her SLAT. I would argue, even though the amounts are somewhat similar, maybe you can make them different. Maybe she buys a $15 million policy. Aren't the economics different? If you go back and look at the Grace case, I think some people misquote it. What the Grace case, my reading of it, says that the parties have to be in a different economic position after the trusts are set up than before. So if husband had $10 million in his name alone, and he puts it into a trust for wife, so she's now the beneficiary of the earnings and principal distributions by, say, an independent trustee with discretion of $10 million of investment assets, and husband's now the beneficiary not of $10 million, doesn't have control over $10 million, but rather has insurance primarily that'll benefit him if and only if and when his wife passes away. I think those parties are in very different economic positions. Why not use an insurance plan, not just to address the risk of premature death, which is important, but to differentiate the SLATs? The Grace case again said the parties should be in different economic positions. So that's certainly addressing access. SPAT, hybrid DAP, and DAP provisions, I think, belong in every SLAT discussion. Not saying that's a standard of practice. You can have all kinds of hurdles. So, for example, if the couples are working, and again, tie into insurance coverage. Do they have a disability policy if they lose that income? But let's say they have reasonable disability insurance and they're working. Maybe you put a fuse on one of the trusts that husband can never get any benefit out of this trust until 10 years and 1 day after the transfer. 10 years and 1 day correlates with the Bankruptcy Protection Act provisions where a trustee in bankruptcy can disavow a trust for 10 years, a self-settled trust. So 10 years and 1 day puts you beyond that. But it also gives a very different economic result. If wife can benefit from day one and husband can't benefit for 10 years, substantial difference. And maybe with some forecasting and insurance planning, that works. Loan provisions, tax reimbursement provisions, the right to add charitable beneficiaries. Lots and lots of different options. We've talked about asset protection planning. We've talked about basis planning. Fiduciary choices are really important. My default preference, And there's the Levine case, which was a split dollar insurance case, waxed on about how important it was to the court's favorable holding that I don't remember the name, but there was a business partner who had independent business judgment and was sophisticated that was named in certain fiduciary capacities. And I'm pretty sure it was South Dakota Trust Company was named in other fiduciary capacities. And the court talked about how important it was to have knowledgeable, independent fiduciaries. Too often, I see SLATs done, non-reciprocal SLATs with husband and wife as trustees. I understand that the law permits that. I'm not saying anything's wrong. So if no one should ever quote this saying that what a lot of practitioners do is wrong. It's not. But think about the benefit to asset protection, estate tax exclusion, having New York or California, respect the trust in terms of non-grantor trust status. If you have an institutional trustee and you can not change your investment advisors or any of the investments, you just have an administrative trustee in, let's say, Nevada, and you can get an administrative trustee for a fairly modest annual fee. Think of the benefit of an insurance policy. So spouses trustee, it's simple, it's easy. Clients are comfortable. There's no cost. The concerns are, will they adhere to formalities? Will they just get sloppy because they're not professionals and don't understand the importance? Bigger problems if there's a divorce. Isn't it better to have an institution if you're really worried about divorce? You could name a non-spouse trustee. I like corporate trustees in trust-friendly jurisdictions. Do you use bifurcated trust provisions, investment advisor or trustee, distribution advisor or trustee, insurance trustee, art trustee? There's so many different variations. Again, when we're talking about a SLAT, I think there's a big difference between a SLAT formed in New Jersey with the spouse beneficiary as trustee with a HEM standard versus a SLAT formed in Nevada with an institutional trustee and a separate investment advisor, et cetera, et cetera, et cetera. I think you're on very different ends of the spectrum in terms of the respect that may be afforded to that and at least the optics of independence that's there. Should you put the investment advisor acting through as a manager of an LLC that's formed in Nevada where the trust is, as opposed to having an individual in New Jersey? Lots and lots of variations. So again, this idea of a monolith SLAT, I think, is misleading. Power holders, 5 and 5 power. We talked about that and how powerful it can be. Hybrid DAPT and SPAT, incredible powers, and you're giving a non-fiduciary the right to add somebody back or direct payments of trust assets to the settler spouse. Power to loan, independent trustees, and so on. The various assets that are there and how they're set up. If the client, based on the financial projections, may need more access to the assets, maybe you gift some assets and sell other assets, so there's still a note in the estate. Maybe the note is still harder for a creditor or claimant to reach, and it assures some payments back to the client. So when you go through it, and I forgive the hokiness, but I think it highlights the point that's very important. When you're talking about SLATs, SLATs are good, SLATs are bad, SLATs are bad in divorce, SLATs are problematic because of the reciprocal trust doctrine. I don't disagree with any of the comments any of the commentators have said, but what kind of SLAT are we talking about? There's such a myriad of differences that can be built in. The continuum from a really simple home state kind of islet to a sophisticated asset protection hybrid DAPT with multiple different trustees is so vast. I think it's you got to be very careful making generalizations about any particular technique. All right, so I was wrong. I had the Grace slides here, but we've already talked about it. It's interesting. If you haven't read Grace, you could read it in the slides. You can go back to the case. It's not long. It's fascinating to read Grace, to read Smaldino. Here's the site for the New York case I mentioned. Forgive me again. I forgot that I had it at the end of the slide deck. CS versus RH. Fascinating case. I think one of the biggest risks that advisors face is where one spouse is overly controlling the process and we're jointly representing the spouses. I think that's a greater risk, perhaps, than the risk of using SLATs in light of the potential for divorce. So SLATs to me are not inherently bad, but bad actors are, or bad planning can be. So hopefully this was helpful and practical. You've hopefully stayed awake for 90 minutes. Um, so thank you kindly if you're still awake. And if there's any questions or comments, we can try to take them. Eric, you look excited.
Thank you. I
I
don't
plugged
see any.
insurance. You should be happy.
I'm always happy with that, Marty. Thank you. I don't see
Eric
any
is paid me
questions.
for all those plugs, by the way. But I shouldn't. Oh, I
Yeah.
shouldn't have said that.
I don't see any questions in the Q&A other than someone asked, is a floating spouse face up or face down? So I think that might be an attempt at humor.
I
Um,
think that's the oh God, now I'm blanking on the name. What was that show with Tony The Sopranos?
yeah,
Tony Soprano
yeah,
had yes, but not me.
right. So,
I'm curious,
but
just if I can pose a question, I'm curious, does this change anyone's perspective on slats and divorce, slats and reciprocal trust, taking a broader view with spats and hybrid DApps? Does any of this give anyone different thought on how they'll approach slats or the way they draft slats and how they present it to clients? I'm curious if I had any meaningful impact.
well, let's give everyone a few minutes to respond or put some comments in the Q&A or raise their hand or whatever it may be. But, for me, Marty, and you and I have talked about this and probably will continue to do so. I think sometimes, we start off with people hearing the generic term and then they start seeing all the variations. And sometimes it gets a little overwhelming, because you start to think that you have to learn about every single variation or every single deviation. And for me, it's more recognizing an opportunity. When you're sitting out in the field with a client and a client brings something up, it's about recognizing, hey, it's not option number 7 of the 31 different flavors. It's more, something, here's an opportunity, and I think I need to be the catalyst to get this client to sit down with someone like you or a trust and estates attorney to say, it's time to visit this issue and to talk about the estate plan and to talk about what your goals and objectives are. And I think what I've learned the most from every time you and I have had these conversations, and it's not just about slats, but it's about DApps, it's about split dollar, it's about insurance, it's about everything, is, you have to approach it from the perspective of creating options and flexibility, because we can plan for the disasters, but we can't plan for the disasters we don't know about, because you don't know what you don't know. So I think it's, you and I have talked about, estate planning and taking, setting up trusts for clients. And, I'm one of the most pro trust wealth management professionals there is. And, but one of the things that is often never talked about is, everybody talks about divorce, but people don't talk about alcohol and drug abuse,
Very good point. By the way,
and and how
mental
that
health,
how that impacts how that impacts children and grandchildren, and sometimes not until later in life.
wonderful point. Mental health issues, including addictions, affect 1 in 5 Americans.
Yeah, yeah, I
That
mean,
20% rate, and I haven't correlated it to wealth, but I will comment, that 20% rate may be higher than the divorce rate for our wealthy, highly educated long-term marriage clients. How many of us really proactively address alcohol abuse, drug abuse, gambling addictions, mental health issues in our planning? We can't do everything, but I think your point about being overwhelmed is valid. But a couple of comments. I think if you start with not an acronym or a solution or a plan, but with a Lego approach and you build blocks, everybody knows that insurance could be used if you have a trust plan. But if the client's not insurable, that planning is off the table. You move on to something else. Now maybe we need to talk about adapt or hybrid adapt. The client can buy a 20-year term policy that solves all these problems for a modest amount of money. Why am I introducing more risk of having a client create adapt in South Dakota when they live in New Jersey? Keep it simple, keep it local, and buy the
and
insurance.
And the 20-year term policy also buys one thing that people can't buy. It buys time.
Yeah.
It gives you 20 years of flexibility, 20 years of options. Usually you have conversion features there. It manages risk for 20 years, and it opens the door to a slew of other options. But that's a different conversation. But I think, when you're talking about divorce and you're talking about mental health issues and special needs issues and drug and alcohol addiction or addiction in general, which as everyone here knows, is something that I am intimately familiar with because of my spouse. Um, you know, it's that flexibility and options conversation that you can build into trusts, and you can layer in those things and give a lot of flexibility and a lot of options. And it's not because you don't trust your children, it's not because you don't trust people, it's perhaps you don't trust the world that's out there around the people we love. But in I think we have another question here, Marty. So the question is, could you speak to a SLAT where state law permits they could be written to fund a credit shelter trust for the surviving spouse of the grantor at the death of the beneficiary spouse?
That's the so-called backdoor SLAT.
Can you talk about that, Marty?
No. So
Okay.
what a backdoor SLAT is husband sets up trust for wife. And what you want to do is make sure husband's protected against the risk of premature death. First question, does the state law, and I don't know the answer, maybe somebody else on the call does New Jersey expressly permit a backdoor SLAT and make sure it's out of the estate and protected from creditors? A number of states do. And forgive me that I don't know, because most of the trusts I set up for all the reasons like the uncrossing are in trust-friendly jurisdictions, DAP jurisdictions. But if state law permits a backdoor SLAT, that may then be a more secure and less risky way to provide for premature death. But I would also evaluate that term insurance policy, which is the better
But
way.
but Marty, so for example, something like this could be done in Nevada, correct?
Yeah, for sure. But
Okay. So
In Nevada, I could be the husband that sets up a trust for wife. The husband could be an immediate beneficiary under adapt. He could be a adapt beneficiary after 10 years and a day to avoid the bankruptcy act issues. The husband could have you, Eric, as an independent non-fiduciary, have a special power of appointment to appoint assets to the husband. Or the husband could let you add him back or descendants of his maternal grandmother as a beneficiary. So there's lots of different options.
so Marty, so let's say the husband sets up this SLAT for the wife and makes himself a permissible or allowable beneficiary in this backdoor SLAT setting, and you address the asset protection features. But now, if you do the reverse, you can't put that same feature in there for the spouse because you have to avoid the non-reciprocal trust doctrine.
I,
So you,
I but let me comment. First, the way this is exercised typically, but there may be variations that I'm not thinking of right now. Husband sets up a trust for wife, a SLAT. Wife has a limited power of appointment to appoint to like the equivalent of a credit shelter trust back to the husband. And she exercised that power in her will. I would certainly want to wait a little bit so it doesn't look like an implied arrangement. But if you're in Nevada, worst case, maybe it's adapt anyhow. I
so
can't,
so if
there's
you're
no,
if you're
but you raised
so
another great point. Let me, 1 second.
well,
You
hold
raised
on.
another great point. If you have the backdoor SLAT in one trust, do you do it in the other? I would suggest your gut is correct that you shouldn't, but there's no definitive rule on what makes trust reciprocal. Would that one provision make the trust reciprocal? But why do it? If you put a power of appointment for wife to appoint to a credit shelter like trust for husband, why not have the other trust have a DAPT or hybrid DAPT or SPAT provision? So they're very different.
So Marty, going back to the question and the example relative to it, if the husband sets up a trust for the benefit of the wife and she has a limited power of appointment to direct back to a credit shelter trust for the husband in case of her death, is that a reason that you no longer have to make the husband a potential beneficiary of that
Yeah,
trust?
Yes.
Okay.
And
So
again, you're
really all you're
highlighting that
doing,
there's lots of options. I believe
no,
Florida
no, no,
passed a law, and there's, I think,
but
over a
Marty,
dozen states that permit
hold
it.
on. In this case here, so you're really just mitigating the risk of a premature death, which insurance can also address. But at the same time, there's a whole series of other things that need to be addressed as well. So you can do this in, if you do this, you also have the asset protection concern. So you can do it in states like Nevada. Um,
There's
but what?
just to interject, there's a number of states that are not DAP jurisdictions that have also enacted legislation permitting that. I just don't know offhand which
Yeah.
ones.
What do you like about this approach, and what do you not like about this approach?
I think, different strokes, different folks. I think you need to find what makes sense for a client. And again, if the client's eminently insurable and healthy, and needs insurance anyhow, maybe insurance solves the problem and you do a simple New Jersey non-reciprocal SLAT. If the client's not really worried about asset protection, maybe you don't need to go to a jurisdiction like Nevada or Alaska or South Dakota, Tennessee. But if the client's really concerned about asset protection, maybe you get them in the right jurisdiction and get started. If the client doesn't have a lot of money to spend now or is fee sensitive, maybe you start with a New Jersey trust and give a trust protector the power to move it. I think as you go through, and everybody on the call knows the facts about their client after the first meeting, right? You're going to eliminate most of these options fairly quickly, and you're going to start to recognize which ones kind of make sense. But that's also why I like the conceptual framework of using drafting software, because as you go through a template, if you don't use a standardized template, looking at all the options gives you ideas as you go through, and you may change what you're suggesting to the client. It's almost a
Mm-hmm.
checklist of all the things I've talked about. If you use any drafting software to draft an irrevocable trust, SLAT like trust, you're going to see 50 different buttons to push in any of the software, whichever one you use, that will help remind you of all these options, and you think about it as you go. And all I do is I discuss what I'm doing and thinking as I do it, and AI generates a memo at modest cost. Yes, you got to review it and spend some time with it, but modest cost compared to the old style memo drafting that documents all these options. And then I can copy you as the insurance person and the CPA and everybody on this memo so everybody can weigh in on what we've talked about.
So we'll give it another few minutes for questions. But while we're waiting for questions,
Yeah, I'm
Marty,
going to have
let me
to head
just
out
ask.
soon. Forgive me.
Yeah, let me just. Yeah, no problem. Let me just ask you if you can make it brief. We're talking about these powerful, flexible, advantageous trusts, whether they're dynasty type or SLATs or DAPs or a combination of both. Um, you use trust protectors in most of your trusts.
Yes.
Okay. And do you use, other than a situs based administrative trustee, do you believe in using also like a distribution trustee, an independent trustee, an investment trustee? What's your approach there?
Almost all my clients have investment trustee provisions because many of my clients have either a relationship with a financial advisor that they want to continue to use, or they have private equity or real estate holdings, and a directed trust structure is necessary for that. I
Mm-hmm.
rarely have used separate distribution trustees because I really want to have that very tax sensitive power held by an institution. Every now and then a client, insists on having somebody they want to name as being in charge of distribution. So you do it. But I think I prefer the approach of letting that be handled by the institution.
But that could also be a distribution advisor. Doesn't necessarily have to be a trustee, correct?
Yeah, I'm not sure that you're making much difference in that other than the fiduciary capacity, but I think that even the
Yeah,
investment advisor or distribution advisor is acting in a fiduciary capacity. So I
got
don't
it.
know if the terminology makes that much of a distinction.
Got it. Well, I don't see any other questions, and I know you said that you had to prepare for the next meeting. With that being said, thank you very much, everyone, for attending. We hope you found this very informative and you know productive and meaningful. I certainly did, and from some of the comments I received, it looks like it certainly was. Um, So thank you very much for attending. Have a
Before
great
everyone
day. And
runs,
Marty,
I would love to, if anyone has thoughts or comments about what I said, whether you agree or disagree, I'd love to hear it about my different perspectives on some of this, some of the statistical data that I talked about, the drafting approach, the use of AI to generate a drafting memo, which is a new thing we're just tinkering with. I'd love to hear anybody's comments or thoughts. So please do email me.
we will provide you, Marty, also with the feedback that we gather after the presentation. But we, on behalf of the board members and guests, we would like to thank you, Marty, for presenting. It's always an honor and privilege and a pleasure to have you back with us at the Greater New Jersey Estate Planning Council. So thank you very much.
You were my home base for most of my career.
Yep, that's great. Thank you, everyone.
Take
Have a
care,
great day.
everybody. Good luck.
Thank you, Marty.
Thank you.